As you all know, we are here today for oral argument before the New York Court of Appeals, which is New York's highest court, on an oil and gas industry challenge to the authority of the town of Dryden to use land use regulation in defense of its property values, economic development plans, and community character. That authority is grounded in constitutional provisions protecting home rule and statutes that implement the constitutional requirements. They're also grounded in court decisions which recognize that zoning is one of the most important functions that a local government can provide. Under those principles, a court cannot find that a state statute preempts local zoning unless there is a clear expression of legislative intent to preempt. Now, we know what a clear expression of legislative intent looks like because we have express preemption clauses in other statutes relating to everything from hazardous waste disposal facilities to casino gambling. And there is nothing of the sort in the oil, gas, and solution mining law. In fact, that law, which I'll call the OGSML, is utterly silent as to zoning or land use or planning of any kind. And under the principles that I just described to you, silence cannot be construed as a clear expression of intent to preempt. So we believe that the court must find that the oil, gas, and solution mining law did not preempt local zoning. There are also very clear precedents from the Court of Appeals itself that support our view. The court has recognized a fundamental distinction between the regulation of the oil, gas, and solution mining industries and regulation of land use. The state has complete power over the regulation of the technical operations and activities and processes of the industry, and Dryden does not contest that. But the locality has authority over land use and zoning. And both of these two regimes can operate harmoniously. In those circumstances, courts are obliged to find that the state statute does not preempt the local statute, and therefore we are hopeful that the Court of Appeals will affirm the decisions below, which found in favor of the town. And I will just mention that every court that has reached this issue so far in the state has found in favor of the local right to zone to protect against the impacts of the oil, gas, and solution mining industry.
So I'll follow up a bit on what Deborah was discussing. So this right of local communities was something that 5 years ago no one thought communities had. They thought that there was nothing that could be done. Oil and gas drilling was coming. It was going to be a train wreck, sort of like the back in oil cars now. But it was going to be a train wreck, and there was nothing you could do about it except basically brace for impact. And this idea that communities could use land use authority to prohibit gas drilling, and that was not a regulation of the industry that was prohibited, was a novel concept. So to be here now, 3 years after the first bans were passed using land use authority, and have won at the lower court level and at the appellate court level, and to now be in front of the Court of Appeals, the highest court here in New York, is just a tremendous victory, I think, for our side. And we're very hopeful. We're perhaps a little more optimistic, or willing to share our optimism more publicly than Deborah's modesty would have her speak. But we really believe that there would be very little basis for the Court of Appeals to not follow and uphold the opinions of the courts below. And in fact, you can look at the amicus briefs that were filed in the case. API, Chamber of Commerce, supports the rights of industry. NRDC, Sierra Club support the right of the towns, typical where you'd expect their chips to fall. But 13 law professors, the leading law professors on land use and zoning, filed an amicus brief in this case, and they believe that the Court of Appeals should in fact uphold the rights of the town. So we think that's the most significant of the amicus briefs that was filed, and really gives an indication of where this case should land and be decided. So thank you.
Thank you. And I want to say thank you to the hundreds of people in Dryden and across the state and beyond that have helped us get to this point. It's been a struggle for a town like ours. We're quiet. We tend to mind our own business. We did not ask for this struggle, but I'm glad we were able to take it on. I'm glad we were able to lead the way for other communities in New York State and around the country. I've talked with people from Michigan, California, Colorado, Texas, who are watching very closely what we do and whether or not we can succeed. I'm confident that we can. I try to imagine occasionally what it's like to live somewhere where the laws prevent people from doing what they know is right, what we know is right. I can't imagine it. So we're confident that the court will uphold our ability to maintain the economy and character of our community. That's all we're asking.
So questions?
Has the highest court in any other state upheld a law like this, or are we the first to get to the highest court in the state?
The high courts of a couple of states have addressed preemption, but they have addressed it under a different state rubric. What we do know is that there are states, several states that do permit complete bans on oil and gas development within localities. Texas is one of them. Oklahoma is one of them. California. Illinois, in fact, gives the towns power to veto it. The oil and gas industry actually has to go and get permission. If they don't get the permission, they can't come in. It's not like the towns have to step in and actually do anything in order to keep it out of the towns. So all of these obviously are states where the industry is thriving, notwithstanding the bans, and the dire predictions of the industry that it's going to collapse in New York if the court upholds the decisions below, we think are just fear-mongering in the absence of a good legal argument.
Supervisor, what's Dryden like? And was there anybody who wanted drilling?
There are some people who had leased land for drilling before the ban, but the overwhelming majority support the ban. No one came to live in Dryden or stayed in Dryden because they thought they were going to get rich on gas drilling. We live there because it's farming. Our main industry is education. It's a beautiful country town, 94 square miles, 14,000 people. It's a great place.
How far are you from the areas that the DEC would make off limits? Are you sort of right over Marcellus Shale?
We're on the thin edge of Marcellus Shale.
And if folks are interested in seeing a little bit more about Dryden and the town, there's a video at earthjustice.org/fracking that gets into a little bit of the history of the ban and gives you a sense of the town and the people there.
Is there a potential federal jurisdiction? Say whoever loses, can they go to the feds?
No, this is strictly a state claim. This court has the last say, so it will decide the issue once and for all for the whole state, and we will know the answer when they make the decision.
Can Deborah or Helen just speculate on how unusual would it be for this court to rule differently than all of these previous decisions?
I don't speculate. I'm the one always on the edge of the envelope. So, you never know. The Court of Appeals is the Court of Appeals. They get to make their own case law. And completely reversing the line of precedent that starts with this case called Frew Run and goes forward, which has upheld the rights of communities to use land use authority to entirely prohibit resource extraction in their town. The court came out and there's a case that said that communities have no obligation to allow resource extraction anywhere in their town. And so that's the precedent that the Court of Appeals is working with. And so they could change that. That seems unlikely. And in fact, in Pennsylvania, where the legislature attempted to make it crystal clear that zoning didn't apply and industry could frack anywhere and everywhere, sort of like green eggs and ham, the Supreme Court in that state, Commonwealth, found that that violated the constitutional rights of the people for their expectations for peace and quiet enjoyment, healthy environment, and the like. So even in Pennsylvania, the court found that there was no right to frack anywhere and everywhere. And so for New York to go and take a more onerous route, given our long history of home rule, seems very unlikely to us. So.
If this court took it despite a unanimous mid-level court, was somebody who's practical legal questions going to
The standard is there an issue of statewide concern? I don't think anybody had a question that this is an issue of statewide concern. And I think the court recognized that if it didn't take the case now, it was going to continuously be asked to take it in some other context. There are other cases that are coming up through the pipeline. There's one that's pending in the 4th Department right now. Why would the court want to wait? It would be much better for everyone to settle it once and for all, and not put itself in the position where it's expending unnecessary resources time after time after time, resisting the urging of both sides, really, to make a decision on the preemption question.
Pipelines, is there an implication that the same sort of zoning rules could apply? We're talking essentially about what's under the ground and whether or not a town has the right to regulate that. Obviously, the industry says no, according to the state's mining laws. But how about with something above ground, like a pipeline? Can a community use this now in the future to zone against a pipeline coming through Dryden or somewhere else?
The pipelines are governed by an entirely different regulatory structure. And the federal transmission lines under the Natural Gas Act, it's absolutely clear that federal law preempts. So these particular rules are not going to stop federal pipelines if the Federal Energy Regulatory Commission issues a certificate. The oil and gas development is under state jurisdiction. The state has complete authority to decide whether or not the wells go in. And so there's really no question about these other preemptive regimes with respect to the wells.
Helen, do you have any sense of how many towns might be on the fence waiting to see if you prevail? It might be adopting bans, something like that?
I think it's a very high number, and we talk with people constantly, and in fact our recommendation to towns that are thinking about moratoriums at this point is to wait. They might as well see how the court decides and just adopt a zoning amendment rather than go through the trouble of adopting a moratorium at this point and then a ban later this year. But there are probably at least 40 or more communities that are basically waiting to see what happens. Most communities don't have the resources and the bravery that Dryden had to go ahead in the face of industry threats. And industry hasn't just threatened towns with lawsuits. They have threatened board members with individual personal liability for passing these sorts of laws, which has just a tremendous chilling effect when you're sitting there trying to answer town board questions about, can they take my house away if I vote for this law? They can't, but you can. Anybody can sue anybody for anything, and in the absence of having a definitive Court of Appeals decision, there are a lot of people that are intimidated by industry's threats. So this really would clear the way for a lot of communities here in New York, and will be an inspiration to communities around the country that are working on this issue. So we're very appreciative of Dryden.
Marianne, I was hoping maybe you could follow up on that. I mean, Dryden, at least in hydrofracking circles, has become, kind of the poster child for this debate, and has been for a few years now at this point. I mean, is that what you had intended at first, and are you comfortable with that role?
I don't think that's what we intended. We certainly knew there was a risk of being sued, but our intention was simply to clarify our zoning that we do not allow heavy industry of any kind, but gas drilling in particular. And we learned a lot about this over the 2 or 3 years prior to changing the zoning. We knew we believed we were on solid ground with the law, and I'm happy to say that the courts have upheld that. It's a largely farming town. I don't know if you know farmers. Farmers are pretty stubborn, and I think that's what gave us. When we knew we were right, we didn't have too much trouble standing by it.
If the court did decide against your position, I guess what would then happen?
Oh, we'd find another way. We know this is wrong for our community at this time. Happily, it's not a decision you have to make in a hurry. We know the gas isn't going anyplace. We know we may need it sometime in the future more than we need it now. But we're not going to allow it now, she says optimistically. Confidently.
Other questions? Just want to let folks know that Catherine Nadeau of Environmental Advocates of New York is also here, and if folks have questions that relate to legislative stuff and other things, feel free to grab her as well. Thanks everyone, and the arguments are at 2 today. We hope you can join us and see what happens in real time.